Mr. President, distinguished members of the Court, it is a great honor and privilege to appear before you on behalf of China. China is committed to promoting the rule of law in international relations, stands in firm support of the Court in preserving and safeguarding international peace and security, international order, fairness, and justice. Dealing with the question of Palestinians served as a litmus test for collective conscience of humanity, the wisdom of United Nations, and the authority of international law. The question of Palestinians has persisted for over a half a century, inflicting sufferings across generations. Countless Palestinians have been waiting in vain their entire lives. Yet, there remains no glimmer of hope in their efforts to restore the legitimate rights of Palestinian people. Fundamentally, the foundation of two-state solution has been continually eroded. The relevant UN resolutions have not been effectively implemented. China has consistently supported the just cause of the Palestinian people in restoring their legitimate right. Chinese President Xi Jinping has stressed on multiple occasions that China calls for comprehensive ceasefire and early solution to the question of Palestine on the basis of two-state solution through negotiation. China submitted its written statement to the Court last July. Today, I would like to further elaborate on China's view. My statement will be three parts, dealing with respectively the advisory jurisdiction of the Court, self-determination of peoples, as well as jus ad bellum and international humanitarian law. Mr. President, I will now turn to address the matter of jurisdiction. In this regard, China submits that the Court has jurisdiction over this case, and there is no compelling reason for the Court to decline to exercise its jurisdiction. China observes that some written statements submitted last July claim that there are compelling reasons for the Court to decline to render advisory opinion. Their main concerns are, first, an advisory opinion would circumvent the principle of consent. Second, the advisory opinion would undermine the established legal framework for resolving the question of Palestine of adversely impact negotiation process. China is of the view that these two arguments are not tenable. First, the subject of present request falls within competence of the General Assembly and has always been on its agenda. Therefore, the Court, by rendering advisory opinion in this case, would not circumvent the principle of consent in the settlement of bilateral dispute. The question of Palestine with origin in this mandate system on the League of Nations go beyond the scope of bilateral affairs between Palestine and Israel. It directly relates to the responsibility of the UN on international peace and security. The UN has permanent responsibility toward the question of Palestine. Second, the issuance of advisory opinion by the Court would not contradict the established legal framework or disrupt negotiations to settle the question of Palestine in accordance with international law. The Court's advisory opinion will not set up new legal framework or rules. Rather, it will find its basis in the established legal framework, including relevant Security Council resolutions and Oslo Accords, and present an interpretation of relevant legal questions. Furthermore, the advisory opinion will offer clearer legal guidance on the legal issues involved in the negotiations, thus facilitating the relaunching the negotiation process. China supports the Court in discharging its jurisdiction in accordance with the law, with focus on identifying, interpreting, and applying existing rules, upholding the purposes and principles of the UN Charter, providing legal guidance to UN in dealing with the question of Palestine, and fostering proper settlement through peace talk. Mr. President, now I will turn to the Palestinian people's right to self-determination. The Palestinian-Israeli conflict stems from Israel's prolonged occupation of Palestinian territory and Israel's long-standing oppression of the Palestinian people. The Palestinian people fight against Israeli oppression and their struggle for completing establishment of an independent state on the occupied territory are essentially just actions for restoring their legitimate rights. The right to self-determination served as precise legal foundation for their struggle. Self-determination of peoples is a fundamental principle of modern international law, enshrined in the UN Charter and collective human right under customary international law. In 1955, during the Bandung Conference, the Chinese Premier and Foreign Minister Zhou Enlai solemnly declared, I quote, "full support of the principle of self-determination of the peoples and the nations, as set forth in the UN Charter, and took note of the UN resolution on the rights of peoples and the nations to self-determination, which is a prerequisite of full enjoyment of all fundamental human rights." End of quote. This declaration was fully incorporated into the final communique of Bandung Conference. Let me clarify that self-determination only applies to two scenarios, namely peoples under colonial domination or foreign occupation. Under no circumstances does the right to self-determination offer any basis for any part or group within the sovereign state to claim a so-called right to secession. International law does not recognize the existence of right to so-called remedial secession or remedial self-determination. The Palestinian people, being a group residing in territory under foreign domination, is a sui generis in international legal person as a whole. The right to self-determination of Palestinian people has been consistently reaffirmed in multiple UN resolutions and the War Advisory Opinion. This is also widely recognized by most states and international organizations. The Palestinian people enjoy the right to self-determination, which includes 5 main aspects. First, the right to preserve territorial integrity. Second, the right to maintain national unity, that is, Palestinian people in its group identity collectively enjoys and exercises the right to self-determination. Third, the right to freely determine the political status. Fourth, the right to freely pursue economic, social, cultural development. And fourth and fifth, the right to permanent sovereignty over natural wealth and resources. Every state is obliged to promote the realization of the right to self-determination and to refrain from any forcible action which deprives peoples of that right. In pursuit of the right to self-determination, these people have the right to engage in struggles, seek and receive support. On the basis of that right, Palestinian people declared the establishment of State Palestine in 1988, which has been recognized by over 130 countries. In pursuit of the right to self-determination, Palestinian people use force to resist foreign oppression and complete the establishment of an independent state is an inalienable right well founded in international law. Various people freed themselves from colonial rule and foreign oppression to realize independent statehood after World War II. Their practices serve as convincing evidence for the right. Numerous other resolutions recognize legitimacy of struggling by all available means, including armed struggle by peoples under colonial domination or foreign occupation, to realize the right to self-determination. For instance, the UNGA Resolution 3070 of 1973, I quote, reaffirms the legitimacy of the people's struggle for liberation from colonial and foreign domination and alien subjugation by all available means, including armed struggle, end of quote. This recognition is also reflected in international conventions. For example, the Arab Convention for Suppressing of Terrorism of 1998 affirms, I quote, the right of peoples to combat foreign occupation, aggression by whatever means, including armed struggle, in order to liberate their territories and secure the right to self-determination and independence, end of quote. Armed struggle in this context is distinguished from acts of terrorism. It is grounded in the international law. This distinction is acknowledged by several international conventions. For example, Article 3 of the OAU Convention on the Prevention and Combating the Terrorism of 1999 provides that, I quote, the struggle waged by peoples in accordance with the principle of international law for their liberation of self-determination, including armed struggle, against colonialism, occupation, aggression, and domination by foreign forces, shall not be considered as terrorist acts. It should be emphasized that the use of force by any entity or individual in the name of exercising the right to self-determination outside the context of colonial domination or foreign occupation is not legitimate. Meanwhile, during legitimate armed struggle by peoples, all parties are obliged to comply with IHL, and in particular, refrain from committing acts of terrorism in violation of IHL. Against the backdrop of the OPT, well-documented and widely recognized facts indicate that Israel's oppression policies and practices throughout its prolonged occupation of Palestinian territory have severely undermined and impeded the exercise and full realization of the Palestinian people's right to self-determination. Mr. President, now I will move on to the issue of international law relating to the occupation. In China's view, the question of OPT involves both legality of occupation per se and the legality of Israel's act during the occupation. These two aspects are governed by distinct legal frameworks. The former falls under jus ad bellum, while the latter is mainly regulated by IHL. Within the framework of jus ad bellum, the principle and exceptions are established by the UN Charter and customary international law. The principle of non-use of force is at the core of jus ad bellum. As corollary of this principle, the prohibition on acquisition of territory by force is firmly established in customary international law. Using force to occupy and maintain such occupation for the purposes of territorial acquisition or annexing an occupied territory by force in whole or in part is each illegal. They are confirmed by the Friendly Relations Declaration of 1970, the definition of aggression of 1974, and the War Advisory Opinion. Israel's occupation has been explicitly recognized as unlawful by several UN resolutions. Following Israel's occupation of the Palestinian territories in 1967, of the Security Council adopted resolutions 242 that, I quote, emphasizes the inadmissibility of the acquisition of territory by war. Similarly, multiple UNGA resolutions affirmed the illegality of Israel's occupation. In addition to the use of force by peoples under colonial domination or foreign occupation in the exercise of their right to self-determination, the UN Charter provides for two exceptions to the principle of non-use of force, namely, the use of force authorized by the Security Council under Chapter 7 and the right of self-defense under Article 51. The exercise of the right to self-defense as an inherent right of states is contingent upon the occurrence of the armed attack against territorial sovereignty of a state. When can an occupying power invoke the right of self-defense? It hinges on whether the armed attack occurs in the occupied territory or within its own territory. In the occupied territory, the right of occupying power to self-defense depends on the legitimacy of the occupation per se. If occupation is unlawful, the occupying power can neither acquire territorial sovereignty nor resort to self-defense against armed attack. that occurred in the occupied territory. This is rooted in the legal maxim, I quote, "No one can take advantage of his own wrong," end of quote. However, this does not rule out the possibility for the occupied power, based on temporary administration as a last resort, to take necessary forcible law enforcement measures against individuals or entity in the occupied territory. Nor does it preclude the use of force by occupying power against the combatants and military targets in accordance with use in battle. These acts must stay within the limits set by international law. Within their own territory, an occupying power is entitled to self-defense against an armed attack. However, the exercise of this right is subject to various principles, including necessity and proportionality, as reflected in customary international law. Under the framework of I-12, the legality of not of the occupying per se will not affect the application of I-12 in the occupied territory. The armed conflict in which oppressed peoples struggle against colonial domination or foreign occupation. In the exercise of the right to self-determination is considered as international armed conflict. Consequently, I-12, including the rules of belligerent occupation, is applicable to all parties involved in such conflict. It is noted that belligerent occupation is a special regime involving the temporary administration of occupied territory by occupying power, and it is governed by two principles. First, the principle of temporary administration, that is, the occupying power can exercise provisional jurisdiction over occupied territory, include limited but necessary legislative, judicial, and law enforcement power, with the obligation to maintain law and order and public life in good faith. Meanwhile, the occupying power is obliged to respect and protect civilians and property in the occupied territory under I-12 and international human rights law. It should serve the best interest of the people of the occupied territories and refrain from plundering resources and property, forcible transferring or deporting inhabitants, practicing apartheid, adopting discriminatory legislation, and other related violations. Second, the principle of non-alteration of the territorial sovereignty of the occupied territory. This is corollary of principle of prohibition on the acquisition of territory by force. It underscores the non-sovereign nature of belligerent occupation. The occupation power is obliged to preserve status quo ante of the occupied territory and refrain from altering sovereignty over the occupied territory. Obviously, the rules of belligerent occupation are applicable to the OPT and should be followed by both parties to the conflict. Facts indicate that relevant Israeli policies and practices have violated I-12 and international human rights law. China is of the view that temporary and non-sovereign nature of belligerent occupation means that an occupying power cannot acquire sovereignty over the territory during the belligerency. Belligerent occupation, under any circumstances, does not have the effect of the lawful annexation. The rules of acquisitive prescription in international law does not apply to belligerent occupation. 57 years have passed since Israel began its occupation of the OPT. Regardless of the duration of the occupation, the unlawful nature of the occupation and the sovereignty over the occupied territories remain unchanged. Mr. President, justice has been long delayed, but it must not be denied. The settlement of the question of Palestine requires mutual efforts from Palestine and Israel, along with the joint efforts of the international community. China encourages both parties to accommodate each other's legitimate concerns, embrace the vision of common, comprehensive, cooperative, and sustainable security, continue negotiating for peaceful settlement, and work toward two states coexisting in peace, and two peoples living side by side in harmony. Mr. President, distinguished members of the court, that concludes China's statement. I would like to thank you for your patient attention. I also wish to thank the registry and all the staff for your kind support. Thank you all.